This one was quite amusing when I received it. It's from Don B. And he says, while researching, I ran across the following from the United States Code. And it's Title 28, Section 541. And it deals with United States attorneys. And it says, which is particularly timely concerning the United States attorney scandal out of the Bush administration, but these are unrelated. It talks about United States attorneys. Subsection A, that the President shall appoint by and with the advice and consent of the Senate a United States attorney to each judicial district. And B, the United States attorney shall be appointed for a term of 4 years. And C, United States attorney is subject to removal by the President. Now, none of that is amusing. The amusing part is this. Found in the historical and revision notes under that section says, the words learned or learned in the law were omitted as unnecessary when you take an affirmative action such as such requirement is not made of United States judges and no reason appears to make a distinction responding to United States attorneys. And Don writes, this revelation certainly explains a lot. So there is no requirement in the law for a person who's nominated to be a judge to be learned in the law, and there is no requirement for anybody being appointed as a U.S. attorney to be learned in the law. They actually took that language out. And so when you take an affirmative action such as remove that language, you're saying it is not a requirement of the job. Isn't that interesting? To be a United States attorney, it is not a requirement that you be learned in the law. And Don was right. It's hysterical in a kind of disturbing way. All right. This from AJ. He says, Dave, enjoy the show. Is there a possibility that you may be able to do a show on property taxes in the near future? And he goes on to discuss his concerns about property taxes. Now, there are several kinds of property taxes, so I want to point out that AJ is talking about taxes upon real property. In other words, if you own land or a home that's on land, taxes upon real property as distinguished from personal property. AJ, there probably isn't a chance that I'm going to do a show on taxes on real property because there's nothing really to talk about. Taxes upon real property have been held both politically and legally to be a valid form of taxation within a state. Now, the federal government does not have authority to do that. But remember, the federal government's authority as far as taxation, it's limited to certain categories. There are what they call constitutional regulations, the 16th, or the argument over the 16th Amendment notwithstanding. And so the federal government is somewhat constrained in what it can tax. The states are not constrained in what they can tax. And we can argue till the cows come home about whether or not a tax upon your real property is a tax upon a right. And I think personally, clearly it is. However, if you've got 230 years of precedent that says it's completely acceptable, and we're talking about from colonial times, and then transitioning to the end of the Revolutionary War when the colonies became states, and they formed their own constitutions, and then years later they formed they ratified the federal constitution and so forth. Through all of that period, And from that time until this very day, as you're listening to my voice, taxes upon real property have been held both politically and legally, and constitutionally, I should say, as a valid form for states and counties, and probably today cities, to raise the revenues they need. So, with that sort of backdrop, with that being the landscape, what is there to talk about? Do we imagine that we can go to court and win that battle? Well, I would say after 230 years, the odds you're going to win that battle are pretty much zero. Do I imagine that there's some mechanism whereby the tax you can somehow slip out